application of Gibson and the Secretary of State for Justice.
Morning.
Good morning.
Yes.
My Lords, my Lady, Mr. David Perry, Queen's Counsel, and Mr. Will Hay appear for the respondent today, and I appear with Mr. Stanbury for the appellant. In fact, Mr. Stanbury is the only one of us who appeared below. So if any of us are looking for a problem below, we will be blaming him. The issue is whether or how accrued interest affects the way in which a default term is served for non-payment of a confiscation order. Mr. Perry, of course, will speak for himself, but from his case, particularly from paragraph 76 onwards, and from discussions with him, I anticipate that he will not defend the reasoning of the Court of Appeal below, although he will maintain the bottom line of the case below. And that's very helpful because it may mean in certain parts I might be able to go through this rather labyrinthine legislation slightly more quickly than I might otherwise be able to do, but we shall see. Can I say that I anticipate further agreement in relation to the following? First of all, this matter relates to repealed legislation, the DTA, Drug Trafficking Act 1994, which has been replaced by POCA, Proceeds of Crime Act 2002. But I think we're agreed that the same issues arise under the new legislation, or the newer legislation, as did under the old legislation. And although along the way I will point up the new legislation, I'll deal with the old legislation if I may. Although the particular case, Mr. Gibson's case, relates to a relatively insignificant number of days, both parties agree that this is an issue that really does need to be resolved.
Well, it could be a very significant one if there were different payments.
Well, exactly.
There's historical precedent for 11 days being very important.
Indeed, I'm not suggesting otherwise. Absolutely not. But the context that I refer to is the example which I provide at paragraph 5, which is borrowed from the Criminal Law Week commentary. On my example, a serious offender gets a windfall of 2 years. So it's very significant. Now, Mr. Perry disputes this calculation, so I was going to open with that.
Well, that's because of the difference in the date which you take as the relevant date, isn't it?
I'm not entirely sure, my Lord, and perhaps we'll have to develop that. But instead of dealing with it now, may I deal with the framework and then come back to it and explain what I say about it? And then, of course, Mr. Perry can tell me where I've gone wrong with it. Now, the argument will involve reference to something around 5 different acts. How they do, or perhaps did, or did not work together. And they involve different versions of those statutes. Indeed, one of them contains an erroneous provision. It's common ground that the lower court referred to the wrong provision in part of its reasoning. But happily, none of those details, which I'll point up along the way, but none of those details will detain us very long because they don't make a material difference. Before I go to the substance of the case, we've referred to some dicta from Lord Judge, generally in terms of this area of sentence calculation in the case of Noon. It's not necessary, I think, to take my lords and my lady to that case, but we've made some references to it, and it's not uncommon, unfortunately, that the plethora of criminal justice legislation leads to sentence calculations problems.
Well, you don't need to convince some of us of that, but Noon isn't a confiscation case.
No, it's not. No. It's a sentence calculation case. It's really the last, paragraph 87, just for your note, where Lord Judge, having made some rather forthright comments about the legislation, comes to the very important conclusion that sentence calculation and the length of a sentence to be served should be, quote, the simplest and most certain of questions. And if I have a theme to my submissions this morning, that would be it. So I intend to go through the statutory framework and provisions first and foremost, and that will take the bulk of my submission time. I will then touch on the Court of Appeal and Admin Court decisions. I'll then come to our submission, and then I'll deal with two aspects of the respondent's case, if I may, because there are certainly two issues which have been raised anew by the respondent in his case to this court, and therefore I think it's convenient for me to deal with them in that order. In terms of housekeeping, we have provided the material in the, we hope, the right order, but we've also put as many of the provisions as possible into the first section just for convenience. So I'm hoping to get through my submissions by referring mainly to volume 1.
Well, that's what we wish increasingly to encourage, and in the hope that we may go electronic with everything else.
Indeed, and I'll refer to page numbers for that reason. Can I just make clear that I have failed slightly? I will have to go beyond volume 1, but only slightly.
Yeah. Good.
So the statutory framework, it's convenient in my submission to deal with it in three parts. First of all, the making of the confiscation order. Secondly, the interest. And thirdly, enforcement. And can I say at the outset, the key provisions are Section 10 of the Drug Trafficking Act, Section 140 of the 2000 Act, and Section 79 of the Magistrates' Court Act 1980. So firstly, can I start with the making of the confiscation order? That's volume 1, starting from page 171. I don't need to go through most of these provisions because they're not in dispute, and the actual making of the confiscation order doesn't concern us here. But again, just for your note, the provisions start at page 171. The relevant provisions of the making of the confiscation order in this case are sections 2, 3, 4, 5, and 6. There are two important dates. The making of the confiscation order on the 29th of March of 2000, and the enforcement proceedings date of the 4th of June 2007. Those are relevant to the versions in force that I'll be referring to. So the amount of the confiscation order was approximately 5.4 million, and the Crown Court gave the appellant 12 months to pay, which took, for interest purposes, the date to 29th of March 2001. So I'll make some references to my case, if I may, as we go along, again, just for your note. So from paragraph 9(1) in my case, I refer to section 9 of the Drug Trafficking Act. And the version in force at the date the confiscation order was made is at page 186. The relevant part of that, subsection 1, where the Crown Court orders the defendant to pay any amount under section 2, sections 31(1) to 3C and sections 32(1) and 2 of the Powers of Criminal Courts Act 1973, powers of Crown Court in relation to fines and enforcement of Crown Court fines, shall have effect as if that amount were a fine imposed on him by the Crown Court. So
this was in force at which date?
This is in force at the date that the confiscation
29300. Yeah,
yes.
I've got it. Yeah.
And it's important in my submission that we keep those dates in mind.
Because it remains in force.
It doesn't later, so that's why it's important.
Okay.
So for our purposes here, the DTA applies the fines enforcement provisions relating to Crown Court fines from the 1973 Act. we'll come to those in a moment, but I just need to deal with broad brush with the rest of Section 9. Now, the confiscation order was to be treated as if it was a fine for the purposes of enforcement. I won't read the rest of it, but Section 9.2 makes clear that a default period imposed won't start to be served until the end of the prison term imposed for the conviction offence.
Yeah.
Subsection 3 deals with multiple sentences and a disregard of suspended sentences. Subsection 4 relates to other disregards for young offenders and the remission of fines, not relevant here. Subsection 5 is important over the page. We say it's a very important provision because it provides that serving the default term does not extinguish the amount payable. So that it can still be recovered by other enforcement methods. Now, we say that's important because it underlines the policy of the scheme, which is the recovery of assets rather than punishment. So default terms are there for enforcement, not punishment, in contradistinction to imprisonment in default of fines, which generally expunges the fine and can be viewed as an alternative punishment. Subsection 6 simply applies confiscation orders made in the Court of Appeal and the House of Lords. So moving from 9.1, that applies two sections of the 1973 Act, which we find at Divider 3.
Just before you leave 9, you passed over 4, and to the extent that it's to do with young offenders, we don't need to look at it, do we? But is it relevant that 9.4a removes what would be the power to remit, which magistrates would have in relation to fines and do not have in relation, as I understand it, to confiscation orders?
Well, it certainly provides that.
That's what it says, anyway.
Indeed, yes, absolutely. Okay. I think the purpose may be that it's not for the lower court to interfere with the order made by the higher court.
Well, it can't just be that, because it can do it with fines, can't it? Or can't it? I think it can, can't it?
Well, it may be then because the confiscation order is the amount of benefit that the Crown Court has determined.
Well, because confiscation orders are tougher than fines.
Well,
aren't they? It may not be right, but they are.
Well, the scheme being draconian, I certainly...
Ghastly expression, but they're more severe than fines.
The application of them may be more severe in fines, but I slightly hesitate because they have a different purpose.
Okay.
The fine for punishment, whereas the confiscation order is to divest the criminal of the benefit of their crime. So the policy would appear to be different. So, if I may, moving on to the 1973 Act, Divider 3, page 232.
Yes, I'm just wondering, you were talking a moment ago about punishment. I mean, I see the distinction that a fine clearly is a sentence imposed for purposes of punishment, and in default of payment of a fine, the alternative is a period of imprisonment as an alternative form of punishment. In this context, on the other hand, the confiscation order isn't imposed as a punishment.
Yes.
And it's not affected by serving the term of imprisonment in default.
That's right.
So what is the purpose of the imprisonment in default? Is it rather like the Victorian world of civil imprisonment for debt, but it's a form of deterrence, if you like, against non-payment and encouragement to come up with the money?
My submission would be that it's part of an enforcement mechanism to force criminals to hand over the proceeds of their crime.
Yeah. Yes.
Subsection 5 in our submission makes clear that that because it doesn't expunge the amount,
Yeah.
then civil enforcement continues, and the purpose is to divest the criminal of, you don't get the choice in the same way as you do on a punishment in a way, that it's an alternative.
Am I right in remembering 9.5, which has a parallel in the non-drugs confiscation as well, was a change which came later than the original introduction of confiscation?
Yes, my lord.
I can't remember exactly when.
I think the original scheme...
1992, possibly?
Yes, and Mr. Perry may be able to assist on this later, but from memory, the original version of confiscation did just follow the fines.
Yeah.
But
Well,
then,
it wiped it out.
indeed,
You start confiscation, don't you, with drugs in 1985 and other offences in 1988,
yes,
and sometime in the early 90s, this change is made.
yes,
Okay, thank you.
indeed.
Yeah.
Presumably because it was found that serving a term of imprisonment was an encouragement not to pay.
Yes, indeed. And I would venture that it's contrary to policy, that the policy was to collect the money and divest the criminal and not to give the criminal a choice.
Right. So where do we go? We go to 232, you said, did you?
So 232, section 31,
Yes.
and the first thing to note, if a judicial finger was kept in the previous page, is that section 9.1 applied 31.1 to 3C. Nothing really turns on this, but in fact, as at the relevant date, 3B and 3C had been repealed and not saved. So I merely raise that, not just to be clever, but just to point out that, in fact, this is so difficult, this legislation, that the drafters made a mistake.
They omitted the 3B and
Yeah.
3C. Wow.
Yes, it's a plea, if you will, to simplicity and plain English in legislation. But that's just a factor, and I think that's agreed between us all. So anyway, looking at section 31, at the point the confiscation order is made, this is the version that's in force. We can see that from the top of the page. And again, just for your note, footnote 6 on the next page deals with the repeal of 3B and 3C, but as I say, it doesn't really matter. Section 31.1 deals with the Crown Court allowing time for payment and directing payment by installments. That's not relevant here. But allowing time for payment, we know in this case that the Crown Court set the confiscation order on the 29th of March 2000 and gave the appellant 12 months under section 31.1 to pay the amount, and that's relevant to when interest kicks in. Section 31.2 is important because it required the judge in the Crown Court to make an order fixing a term of imprisonment in default. So, pursuant to that provision, at the 29th of March 2000, the judge set a default term of 6 years.
Can we just pause there, Mr. Weatherby? Am I right in parking at the back of the brain somewhere that the same rule applies where the Crown Court imposes a fine?
Yes.
And indeed, that is it.
This is the provision for fines,
Yes.
which by section 9 is applied to
It's read
confiscation
across.
orders. Yes.
So that if and when later we need to think about what works for fines and what doesn't, one of the things we need to remember is that when, unlike if you're a magistrate's court, if you're a
Yes.
Crown Court, when you say you'll pay a fine of £5,000, you must also fix a period in default.
Indeed.
Thank you.
So 31.3 I don't think we need to worry about in this case. 31.3a over the page simply provides the table of maximum terms for the Crown Court judge to fix in default. Can I just make a correction? In my case at paragraph 9J, we've referred to 3A as 4. That was just a typo, I'm afraid.
Sorry, paragraph 9
9J.
should be referred to what?
It should refer to 3A, not 4.
Right.
Now, that's all I want to say about 31, but 31 was in play in this case because this was in force at the date of imposition of the confiscation order. So Section 9 applies 31. It's convenient to deal with Section 32 now. I only deal with 32 because this was erroneously submitted, I think, by both parties below and adopted by both courts below to be an applicable provision. It wasn't. The reason for that is because 32 relates to enforcement, and enforcement didn't happen until 2007. So this provision had been repealed on the 25th of August of 2000, so shortly after the confiscation order was made, and it had been replaced
24th of August, yes.
Yeah.
Right.
But its last applicable date was 24th of August 2000. And it was replaced by Section 140 of the 2000 Act. Now, that's one of the key provisions, and I will get to it later if I may. The good news is that for all intents and purposes, although these two provisions are drafted quite differently, nothing turns on the different drafting. Nothing had changed. Section 140 was essentially a replacement. But it's right to deal with 32 because that's what the lower courts did. And we were specifically asked by my lords who gave permission in this court to deal with 32.
Right.
But I'll do it in short order. Now, there should be a replacement page at 236. A gremlin got into the bundles, I'm afraid.
Well, I'm not sure we've got a replacement.
Well,
Oh, this
Yes.
thing, yes.
Yes,
Right,
I'm
amended.
afraid
Yes.
that Westlaw had made an error, which we had corrected, but then for some reason the wrong version went into the bundle. So you have the right version now. Nothing really turns on that. But you have So the 32 applies the provisions relevant to the Magistrates' Court fines to Crown Court fines. So here, by application of through Section 9, 32.2 indicates that on enforcement, the term specified in any warrant of committal issued by the Magistrates' Court shall be the term fixed, quote unquote, by the Crown Court under 31.2, or if that term had been reduced under Section 79.2 for part payment, that term is so reduced. Now we're going to go and look at 79.2 and Section 143, which is the replacement section in due course. So if I can perhaps park that at the moment. But it's correct to say that it's clear that Section 32 contemplated the imposition of the default term fixed by the Crown Court as reduced for part payment made prior to the warrant of committal.
Sorry, say that again.
Yeah, it's clear that Section 32 contemplated the imposition of the default term fixed by the Crown Court under the previous section, as reduced,
Or if that term has been reduced.
as reduced for payments
After.
made prior.
Well, it's quite difficult to make 79.2 apply to prior payments, isn't it?
It's
Anyway, well,
indeed,
That's
absolutely.
where one of the difficulties comes in.
Absolutely, yes.
Yeah.
Yes. 32.3 simply applies the Court of Appeal and House of Lords confiscation orders, and 4 disapplied the Magistrates' Court's ordinary powers of remission of amounts ordered to be paid by the Crown Court, my Lord Hughes' point earlier. Finally, in respect of the making of confiscation orders, the DTA was replaced by POCA in March 2003, and as I say, nothing turns on that. If my lords and my lady want references to the relevant provisions, I can simply give them for your note. the relevant provisions of POCA are section 12, which is at page 1210, section 35, which is at 1275, and section 39, which is 1281. Now, we agree with the Court of Appeal, and I think the respondent also agrees that nothing turns on that, so I'm not going to go to those provisions unless I'm required to do so. The relevant part of the Court of Appeal judgment is paragraph 37, which is at 1950. Now, moving on to the second part of the statutory scheme, interest. Section 10 is the provision regarding interest, and if I can ask my lords and my lady to go back to volume 1, divider 1, at page 188, we get the version of section 10 which was relevant at the time the confiscation order was made. And that indicates in subsection 1, well, I'll read it because it's important. If any sum required to be paid by a person under a confiscation order is not paid when it is required to be paid, whether forthwith or on the making of the order or at a time specified under section 31 that we just looked at, that person should be liable to pay interest on that sum for the period for which it remains paid, and the amount of interest shall, for the purposes of enforcement, be treated as part of the amount to be recovered from him under the confiscation order. And then, so primarily, subsection 1 makes interest payable at all. That's the interest provision. Its final part, which we'll have to come back to in due course, refers to enforcement. So plainly, I say at this point that interest is an amount that is to be enforced. But this case is about how it's to be enforced, and we'll come back to that if we may. Subsection 3, I'll come back to 2. Subsection 3 indicates that the rate of interest is Section 17 of the Judgments Act, which has been described below as a punitive rate.
When was it last changed?
I'm afraid I don't know that. It was referred to as being 8%.
Yes, I mean, it sounds punitive, pretty punitive now, but it might be interesting to know when it was fixed, because it may not have been then.
Well, I don't think it's been. I think the important thing is that it hasn't changed since the financial crisis in 2008.
Yes.
Yeah.
Before that, it was probably reasonably realistic.
Right.
Well, we can check that certainly.
Yeah.
And,
It certainly hasn't. No one's done a thing to it since, have they?
No, as far as
Right.
we're aware. The significance of this, we would say, is that the interest provision stops the offender making money on a large amount by dragging his or her feet.
Yes.
But also it's plainly to encourage payment. So we accept both of those. Now, returning to subsection 2, this again is an important section as well as 1. We say that 2, which the Crown Court may, on the application of the prosecutor, increase the term of imprisonment or detention fixed in respect of the confiscation order under section 31(2), if the effect of subsection 1 above is to increase the maximum period applicable in relation to the order under 3A of that section. So what this does is it allows for a judicial review by the Crown Court judge to up the confiscation default term.
If the interest has taken you into the next bracket
Indeed.
up.
Yes.
As a matter of interest, Mr. Weatherby, do you know whether that happens often, occasionally, never?
We're not aware of any case that it's happened in. Again, I don't know whether the Secretary of State can it's certainly beyond my experience that that's ever happened. But the policy point that we would make is that the policy appears to be that to up the default term is something that Parliament intended to be left to judges. And we say that it's not determinative, obviously, but we say that's an important element of the policy argument here.
What is it? I mean, what this caters for is the situation where the judge was operating within a bracket previously, which now appears to be an inappropriate bracket because it limited him to, say, 2 years, 3 years, 5 years, or 10 years. But by the same token, it doesn't suggest that so long as you remain within the bracket, there is likely to be some automatic mechanism for the increase of the amount you may have to serve by reference to the increase in the total sum due because of interest.
Well,
otherwise, there's no mechanism for doing that. They haven't provided for that.
Well,
if you remain within the 10-year bracket,
yes.
The judge may originally have said, well, you're in the low part of the 10-year bracket. You're only just above the 5 years, so I only impose 5.5 years. And but your interest may have taken you up to, logically, 8 years. This subsection doesn't cover that.
Well, if the purpose of the legislation was to increase the default term because of interest, yes, our submission would be that the legislation would say so.
Well, that's very odd. I mean, why should the legislation enable you to increase the maximum, but not have any provision for increasing within the brackets at all?
Well, it may be that the policy of the legislation in the round is to recover the benefit of the offending, and so the interest only becomes relevant in the discretion of the Crown Court judge for a particular reason. So, for example, if the property was held in, if the assets were held in property which suddenly went up sharply, then the Crown Court judge might say, well, it's fair that the confiscation default term is increased into the next bracket. But we would say that generally, because the policy is to divest criminals of the benefit, the general approach is to recover that benefit rather than to concentrate on recovering the interest. So this is a nod to policy that the length of the term should be determined by judges rather than by an administrative mechanism. And if we were wrong about that, what would we say?
But hang on, you can only increase under 10.2 if it's interest which has pushed you into the next bracket.
Yes.
You can't do it if the value of the villa in Spain has gone up.
Yes, I've given the wrong example, my lord. My lord is quite right. If interest rates went up.
You see, the contrary argument to yours is, I suspect, that you don't need a provision to increase the term in default so long as you're in the same bracket, because Section 10.1 does it for you by adding the interest to the principal.
Well, we would agree with that in terms of civil enforcement, for reasons that I'll come on to.
But not in terms of default.
So the policy is to recover the amount plus the interest, but we would not agree, for reasons I'll go on to go through in more detail later, that deals with penal enforcement. And we would go further than that, and we would say that if it was meant to achieve that, then the legislation would have to be a lot clearer. That Parliament has made a specific provision to allow the prosecutor to go back to the Crown Court to up the default term. So why would Parliament not have made a specific provision to deal with the increase in the amount of the penal term to be served? That would be the way we would put the argument.
Yeah, right.
And again, I'll come back to Section 10 as it becomes relevant to the other sections, but we absolutely don't say that this creates a problem for our argument. The next point, a short point, is that the interest did not in fact accrue in this case till 12 months after the confiscation order was made. So it accrued from the 29th of March. So the version of Section 10 that's relevant is in the next divider at page 231. I've referred to the first version because, of course, section 31 did apply to this case. But by the time the interest kicked in, it was in fact the next version. Nothing turns on that, just for completeness. We make that clear. And the only difference between the two versions is the substitution for the replacement provision, which is section 139 of the 2000 Act. And there, as I say, there's nothing in substance between that and section 31. It's a replacement section. So can I now deal with the third part of this statutory framework, which is enforcement? And again, for your note, we deal with this from paragraph 13 of our case. Can I start with the provisions that are relevant? We've already dealt with the fact that the version of Section 9 in force when the confiscation order was made had these extra provisions which had been repealed. We did at 14 to 16 set out a perceived difficulty with applying the savings provisions. The respondent, Mr. Perry, has helpfully pointed us to the case of Peacock. Not necessary for me to take you to that because we're all in agreement about it, that in fact this court in Peacock at Divider 54 effectively determined the issue, that the transitional provisions saved the DTA scheme for the purposes of enforcement where the confiscation order was made prior to repeal. We raised that again to show the difficulties with this area of legislation, but there never was a disagreement between the parties or indeed a disagreement with the lower court, that we always asserted that the DTA provisions should apply. So I can move swiftly on from those submissions. We looked at Section 9 in force when the confiscation order was made, and that applied Section 31. Of course, the enforcement proceedings occurred only in 2007. As I say, the DTA had been repealed by that point. So the version of...
But continued to apply. But, sorry.
It continued to apply.
Yes.
The version of Section 9 that applied, therefore, was that which was the final version, which I'm afraid isn't in Volume 1, it's in Volume 2, and it's at page 666. Divider 17. And again, this is a version which simply is amended to put the 2000 Act provisions in. The page 666, divider 17.
So it now refers to the 2000 Act rather than the
It does.
1973 Act.
Yes, I'm sorry to have to refer to page 666, but it is in fact important because this is where the lower court had referred to the wrong act. So by the time of enforcement, the final version of Section 9 was applicable by the transitional provisions, and therefore it was Section 140 of the 2000 Act that applied, and not Section 32, as the lower courts and both parties apparently had asserted. As I say, though, happily, for our purposes, that although the drafting is quite different, Section 140 is in effect a replacement section. So there's no material difference for our purposes. I think we're all agreed. I think the respondent agrees with what I say about that as well. Before I move on, nothing else in Section 9 has changed by that point. And the rest of Section 9 relates to how the default term would be served, as we've already looked at. And again, the important provision, so far as we're concerned, is 9.5, that the confiscation order amount remains enforceable, even if the default term is served. So, if the offender pays the full amount before the due date, then the confiscation order is satisfied. In this case, as we know, only a small amount had been paid before enforcement proceedings were taken to activate the default term. The Crown Court fixed the default term under Section 31, but Section 140 was applicable to enforcement. So can I now take you to Volume 1, Divider 7, to look at, very briefly, 139, but really to take you to 140. As I've asserted already, 140 is a central in this case. So 139 at 338, not relevant for our purposes, but was the replacement for Section 31. Section 140, in force in 2007, the version of that is at 341. So Volume 1, Divider 7, page 341. So Section 9 applied Section 140 as if a confiscation order were a fine, subject to the caveats we've already looked at. Section 141 applies the enforcement provisions as if the fine or confiscation order had been imposed by the Magistrates' Court. Subsection 2 simply applies subsection 3, where a Magistrate Court issues a warrant of commitment regarding a Crown Court fine, or indeed here a default period under a confiscation order because of Section 9. Now, I'm going to deal with how the Magistrates' Court does that later for convenience, but again, just for your note, the warrant of committal is under Section 76 of the Magistrates' Court Act.
Where's that referred to?
Page
warrant?
461. But I'm going to deal with that later, so I wonder whether we may park that and come back to it.
Section 76 of the Magistrates' Court Act,
Yes.
1980.
1980.
Yep.
It's in Divider 12, but it's convenient to come back to that if I may. But certainly there is a power for the Magistrates' Court to issue a warrant of committal, and that's why I mentioned it, and I'll come back to it. It's important later.
Yeah.
So 2 applies 3, where, in its discretion, the Magistrates' Court issues a warrant of commitment.
Yeah.
Subsection 3 is the central provision for this appeal, or one of the 2 central provisions, really. The first part indicates that the term specified in the warrant of commitment shall be mandatory, the term fixed by the Crown Court, or the term reduced under the operation of Section 79(2). So it's clear, everybody's agreed, the lower courts, the respondent, ourselves, that the term specified in the warrant of commitment can be no more than the original default term, or is the term as reduced by payments made before the warrant of committal is made, unless an application has been made to the Crown Court under subsection 2 of Section 10. And the judge has set a new higher default term. So the issue, therefore...
That's because of the meaning you put on the words, the term fixed by the Crown Court, is it?
Yes, well, yes.
I mean, isn't there an argument that the term fixed by the Crown Court is one which has in it its own mechanism for increasing?
The respondent's new argument in terms of the deeming. Well, my lord, no, because this is the term, the default term, not the amount.
Well, the default term may be
The
maybe
respondent,
a movable or expanding one, I suppose, is the argument, or maybe the argument.
well, with respect, no, the default term is fixed.
Yeah.
The default term is fixed by the
Oh, yes, I
judge
see, yes, it
on
is.
anybody's
I
argument.
see, yeah.
Yeah.
Yeah. Right, now I'm with you.
Yeah, so it's either that fixed under section 31
Yes.
in this case, or if there had been an application under section 10.2,
Yeah.
that would be the max.
The issue in this case isn't whether it can be increased, it's by how much it's been reduced.
Indeed.
Yeah.
That's the point that I make here about subsection 3. So the issue is how, if or how interest payments affect the reduction of the term to be served after interest has accrued. That's the point. So therefore, again, applying it to the facts of this case, the default term was 6 years. The first question is, how should the term to be specified on the warrant of commitment have been calculated, given that a payment had been made and interest had accrued before the warrant of commitment had been issued? So the answer to that question lies in section 143, read with section 79.2. So, because it's so important, may I just read subsection 3. In such a case, the term of imprisonment or detention under section 108 above, specified in the warrant of commitment as the term which the offender is liable to serve, shall be A, the term fixed by the Crown Court under section 139, in our case section 31, or if that term has been reduced under section 79.2 of the Magistrates' Court Act 1980 part payment, or remission, that term as so reduced. We know remission has been disapplied.
In 143B, you've got the same 3 words, has been reduced, as
Yes.
we found in 32.
Yes.
2, I think, if I
Yes.
remember rightly. Can we just park that? And we need to remember those, don't we? Because it's too soon to look at them yet. But when we get to 79.2, we shall need to look at at how that might work.
Yes. Well, the submission looking forward is going to be that it doesn't work at all unless the fixing of the term specified on the warrant takes account of section 79. So section 79 can't operate by looking at the warrant first.
Quite.
And that's one of the key flaws with the judgment of the court below.
Right.
And I understand that that's accepted by the respondent now. So just reading the rest of that, notwithstanding that that term exceeds the period applicable under the Customs and Excise Management Act, that doesn't have any effect here. And nothing else in section 140 applies, because only subsections 1 to 3 are applied by the last version of section 9. So subsection 4 onwards doesn't apply. It is somewhat complex, this legislation in our submission. So moving swiftly on, if I may, but bearing in mind section 140, to section 79.2, it's divider 9 at 347. And again, keeping an eye at the top of the page, dealing with the version in force at the relevant time, always. So this is the relevant version. The important provision is subsection 2, which reads, where after a period of imprisonment or other detention has been imposed on any person in default of payment of any sum adjudged to be paid by the conviction or order of a magistrate's court, or for want of sufficient distress to satisfy such a sum, payment is made in accordance with the rules of court. Part of the sum, the period of detention shall be reduced by such number of days as bears the total number of days in that period less 1 day, the same proportion as the amount so paid bears to so much of the said sum and the costs and charges of any distress levied to satisfy that sum, as was due at the time the period of detention was imposed. And I add emphasis to that last phrase, which is where I must end up in my submissions in reply to the latest submission by the respondent. So it's not an easy section to read in our.
So just to get it now, you say the period of detention is imposed when?
The period of detention is fixed by the Crown Court judge on the day of the confiscation order.
Yeah. So yeah.
Now that is the point that we say the Court of Appeal got wrong.
Yeah.
And we understand that the respondent will not seek to defend the Court of Appeal judgment on that point.
Yes.
Of course, Mr. Perry can speak for himself. So it starts with that point that the imprisonment is fixed by the Crown Court judge, and it then provides that the default period set by the Crown Court judge is to be reduced in proportion to the amount paid at any point thereafter. So in simple terms, if you pay half, your default term is halved. Now, can I just deal with a point of detail before moving on? It does refer to that period less 1 day. We think, and we'll be corrected if we're wrong, no doubt, but we think that simply is to deal with the next subsection 3, which disposes of fractions of a day. And I think that the less 1 day compensates for that.
Rounds up to 1 day.
So it means that the prisoner doesn't lose out. I think that's the only purpose of that, but I'll be correct if I'm wrong. Now, the obvious starting point for me could be that Section 79 doesn't mention interest at all, but there are two very simple answers to that. The first is that it was enacted in 1980, but also this is drafted for fines enforcement, which doesn't apply interest. So it's not, it doesn't help or hinder either myself or the respondent in my respectful submission that it doesn't mention interest. So returning to the problem that arises in this case, it starts with the point of whether the imposition of imprisonment means the fixing of the default term, as my Lord Mance has just asked me. Whether that's the Crown Court at the time the confiscation order is made, or whether it is the activation point at 2007 when the warrant of committal is made. The respondent argued, and the Court of Appeal held that it was the latter, and that was reached by asserting that the natural meaning of imposing imprisonment is the committal itself and not the setting of the default term. But as I've already said, that we say that was wrong. Why is that wrong?
Well, you have to read in words to make sense of it. It doesn't cater for the obvious and certainly intended likelihood that payments may be made immediately after the initial
Absolutely, yes.
sentence.
With respect, that's quite right. But before we get to that, which is the Inco Europe point that we make in our written case, before we get to that, Section 150, the Interpretation Act, is where naturally we should be looking for the meaning of the words in that act. So if we turn over the page to 348, we've got the Magistrates Court Act interpretation section, section 150, the volume 1, divider 9, page 348.
Yes.
And the penultimate paragraph on that page, impose imprisonment means pass a sentence of imprisonment or fix a term of imprisonment for failure to pay any sum of money.
I suppose those words, fix a term of imprisonment for failure to pay any sum of money, could work equally well, couldn't they, for the Crown Court anticipatory fixing of a term of default and the magistrates actually locking you up for default.
Well, we would say no.
But your other arguments tend to show that,
Yes.
that it can't.
Indeed.
Yeah.
We would say, with respect, that that it either means the passing of the sentence for the substantive offence or the fixing of a default period.
Yeah, but if you've got a, I mean, it may not matter because your other arguments may get you home, but if the magistrates issue a warrant of commitment for non-payment of a fine, are they passing a sentence of imprisonment?
Yes.
Are they?
Well, we would say under,
You say they are.
under Section
Okay.
150, we'd say they are.
Okay.
Even if it isn't activated on the day. As Mr. Perry's point is that the Magistrates Court might well fix a default period but give the offender time to pay.
Yes.
But I don't want to be rude to speak for Mr. Perry, but as my understanding is that he will accept that we're right about Section 150.
Yes, I just wanted to see whether it was sufficiently
Yes.
clear from 150 by itself, or whether
Yes.
it gets
Yes,
home in
but-
effect, because otherwise 79(2) won't work for payments made between the
No,
Crown
right,
Court
yes.
and the Magistrates Court.
Well, I'll take the hint and I'll move on to my second point, which may perhaps score the goal on this one. I just would say in passing that it's unfortunate that neither of the parties raised Section 150 with the lower court, and it may be that was part of the problem that occurred there. But as my Lord Hughes presses me on, if we go back to Section 143 and keep a judicial finger at 347, the interplay between 140 subsection 3 and 79(2) puts this issue beyond doubt, we would say, because if 79 did refer to the point of activation, then Section 143 would involve a circularity. It just can't work. I've described that as a nonsense, and Mr. Perry has described it as problematic, but I think we're on the same page. Further, even to that point, and I just quickly mention this for completeness, if 79(2) did relate to the time of activation when the warrant of committal was made, then it would mean that payments made prior to the issue of the warrant of committal would not count on the wording as it is, query, or with the caveat that, of course, that the Court of Appeal then read in words. We say that is misconceived because INCO Europe, we would say, does not apply here because there is no drafting error in 79(2). It's perfectly properly drafted for the purpose of which it was enacted. So INCO wouldn't bite at all. And it isn't necessary for the reasons that we otherwise say. So we say, just rounding this part of the argument up, that 79(2) refers to the fixing of the default period by the Crown Court as the imposition of imprisonment and not the committal to prison by the Magistrates Court issuing the warrant. And if that is correct, the scheme makes sense, and Section 143 and 79(2) work together. And that would mean that all payments made after the confiscation order is made reduce the default term in proportion to the amount set by the Crown Court on the confiscation order and not the confiscation order amount plus interest at the date of enforcement. Now, again, this is something I'm going to come back to because of the respondent's new argument. But if we can just look at the last phrase of 79.2, as was due at the time the period of detention was imposed. We say that that makes that clear. As I say, I will return to that once more, if I may, because it is of such central importance when I deal with the respondent's alternative submission. Now, that's all, happily, I want to submit in terms of the statutory framework that's in play here. I want to just now turn very briefly to the Court of Appeal decision. We deal with this in summary at paragraph 32 onwards in our case. And therefore, I think I can deal with it quite quickly and with only reference to volume 5. Firstly, we would say that both decisions of the lower courts are forthright in adopting the respondent's submission that 79.2 refers to the point of warrant of committal and not the interpretation that we've just been through. The administrative court referred to the point at which the sentence being imposed as being a straightforward one. And the Court of Appeal referred to it as being clear. And we would venture to suggest that that illustrates the difficulty with this legislation. In fact, it isn't straightforward or clear, for the reasons that we've been through. If I can just briefly take, my lords and my lady, to the Court of Appeal decision. It's in volume 5 at 58. It sets out the issue at paragraph 2. And it sets out the key issue as being determining when the imposition of the term is. At 39, having set out the, well, at 29, it sets out the Secretary of State's submissions, which were that the imposition of of imprisonment in section 79.2 was at the warrant of committal stage, the enforcement stage, and not the Crown Court stage. Sets that out there, and then the discussion starts at 39. The Court of Appeal explains the basis of confiscation orders, that the intention is to strip criminals of the benefit of their offending. And then it moves on to consider section 10 at 41 and 42. And then at 43 and 44, we have the key paragraphs for our purposes. And then really, I'm not going to read through all of this unless I'm invited to, but the conclusion is the second part of 44. Having referred to the wrong section, but nothing turns on that, as I say, it says the language used clearly recognises that it is the magistrate's court in the enforcement proceedings which imposes the term set by the Crown Court, subject to any reduction by reason of section 79.2. The language used is, to my mind, clear that it is the magistrate's court which in ordinary language is imposing the default term. From 47 to 50, the court then recognises that that creates the difficulty that my Lord Mance has mentioned about the literal wording, and deploys Inco Europe to rectify that problem by reading words into the section. Because I don't think there's any difference between my position and Mr. Perry's position on this, I'm content to rely on my written submissions about Inco Europe.
Yeah.
Unless I'm invited to do otherwise, with the caveat that it just might become relevant during Mr. Perry's submissions, in which case I'll deal with it in reply. But as I say, in a nutshell, we say that Inco Europe wasn't applicable here and shouldn't have been applied. So, moving swiftly on, I don't think there's anything else in the Court of Appeal judgment that I need to refer the court to. But our case, we set out at paragraph 40 of our written submissions. We note that neither of the lower courts had found a perfect answer to the issues before them, that the admin court had referred to a lacuna, the Court of Appeal had read words into the statute. We also note now that the respondent has advanced a new alternative submission. All of this in our submission shows that there is a real difficulty with this legislation. I'm not, if I appear to be point scoring here, I'm absolutely not.
Telling us that there's a difficulty about the point before us doesn't score any points. The points only come here because they're supposed to be difficult.
Well, I'm pleased that I haven't been doing that. But it is right that the respondent appears to have reversed his position in his written case to this court and doesn't support the reasoning of the Court of Appeal for the reasons we've gone through. Now, the reason I raise that is to show that actually the underlying policy of all this is not straightforward. And we say that it is tolerably clear, or very clear actually, that the underlying policy behind confiscation is to divest criminals of their ill-gotten gains. But it's not clear how interest payments are to be applied within that. Before I say a little bit more about policy...
No, but I think, there may be policy considerations which have some weight, in the sense it would be perhaps, well, it's certainly legitimate to consider the practical consequences of the alternative constructions.
Yes.
If the interest falls out, does that matter? Does it have any effect? If payments are delayed, if they're made late in the day, does that mean that you get just the same benefit as if they're made immediately, as the encouragement of the statute presumably is, and so on?
Well, ultimately...
I think in your case it does. That the payment late in the day is as good as a payment early.
Yes.
Well, with the caveat that the interest is enforceable,
Yeah.
we're not suggesting for a moment that it isn't, then that may be right. But that is because the policy is to recover the benefit rather than to be worried about the interest. The interest is relevant to no further enrichment from no payment.
Well, the trouble is benefit in year 1 is different from benefit in year 7, isn't it?
Well,
it's downvalued unless you take the interest into account.
Yes, and that's why it remains enforceable in our submission.
Yes, I see.
But we will go on to say that the wording of these provisions can only be read in the way that we
I understand that.
submit, and that the court should not make a strained construction of them on policy grounds, because the policy isn't clear. But also, even if the court were to take the view that Parliament might well have intended the enforcement of interest, then on the wording of the provisions, it's for Parliament to rectify the problem that appears to have arisen. And ultimately, what we will say is that even if we're not right about policy, it's not clear, and therefore it's for Parliament. And it may well be that Parliament didn't consider this. They didn't consider the enforceability in the penal sense of the interest provisions. Now, may I just slightly digress, because I just want to turn to support for my arguments, and I just want to refer the court to the Criminal Law Week commentary, because the arguments that I put forward so far are mirrored, or they might say I have mirrored their commentary in the Criminal Law Week, which we've included in the bundle at volume 560, which is at page 1972.
Is it fully reproduced in your skeleton at 5B, or do we need to go to the...
Well, I'm merely referring the court to it so for your note, really. I'm not going to go through it.
Right.
But I say within that commentary, it is legal commentary support for my arguments that Section 79.2 should be construed in the way that we say, that Section 150 and Section 143 support that.
So where do the commentary is?
It's Divider 60 in Volume 5. Now, can I say straight away, I'm not going to repeat or support the somewhat irascible tone of this commentary, but it's the
Well, what's making me smile is that the author's changed his mind between the commentary on the High Court decision and the commentary on the Court of Appeal.
on one particular point, yes. But in fact, on all the points that I've made so far, the commentary would support mine. Of course, it's only a supporting article.
Yeah. Do we know who the author is?
I'm afraid not.
Well, it's virtually certain to Mr. Richardson, isn't it?
The tone of it would certainly indicate that, but
Is that by reference to some?
but there
You
we
write them all, or characteristic?
He's the editor of the thing, and as far as I know,
rather
he
assume
writes
so,
most
but
of them.
I'm afraid I don't know, and I don't want to.
No, but it's irrelevant anyway.
I don't want to slander him. So
which page is it
well,
exactly?
it's really from 1974, the top of the first column of that, to somewhere on the second column. I'm not going to go through it.
Well, it starts at 1972,
It does.
doesn't it?
It's
Item 8. It's item 8, isn't it?
Yeah, item 8, 1972, but the first part of the commentary on 1973 deals with a jurisdictional point which hasn't been raised, and I certainly don't want to raise it here.
Right.
It then goes on to deal with the substantive issues I've raised here on 1974. But I also refer to it because the example that I mentioned before at my paragraph 5 of our case is borrowed from the bottom of the first column at 1974. Now, I merely changed the figures because I wanted to make it easier to understand or submit on. But this commentary supports, as I say, the submissions that we've been putting. I see my lords and my lady looking at this, so I may hesitate for a moment.
Well, if you want us to treat it as a reason for arriving at your conclusion, we'd better see whether it works.
Of course, yes. Well, I want to go to the example, but I'll do it from my case, if I may.
Yeah.
So it's the bottom right of page 1974,
Yes. Okay.
effectively what Mr. Perry is now suggesting. The idea from which the editor has now departed.
No, I don't think that's
not.
right, but
Well,
We're
not
happy.
far off.
I think it's not far off.
yes.
And we'll see how he puts it.
It's the adding of the interest to the,
Yes.
treated as part of the amount to be paid under the confiscation order.
Right.
Which he then
For
departs.
both purposes.
No, he's repented of it, Mr. Weatherby, you're quite right.
He's
Yes.
it
Well,
only,
his repentance doesn't matter. These,
No, of course.
these are just arguments which we have to consider.
of course, and again, just because this is so complicated, can I say I don't disagree that the amounts are aggregated. It's the application of the aggregation that I disagree with, but that's why I want to come to the respondent's argument.
Well, the application in terms of section 79(2).
That's the part I disagree with.
Yes, quite. That's where it gets
Yes,
crunch. Right.
indeed, and that's
Well,
why I
we
want.
perhaps we ought to get on to it.
Yes, well, I'll get onto that as quickly as I possibly can. But may I just deal with the example? But can I deal with it from?
Well, surely the example. Yes, sorry.
Could I deal with it from my case, because I've changed only the figures, and I've done it just to try and to make it easier for all of us, frankly. So it's at page 43, paragraph 5b of my case.
Well, are you trying to justify the example? Because
Well,
does it need it? I mean,
Well,
it's
Mr.
not comparing like with like. That's the basic problem.
Well, this is applying the Court of Appeal
Yes.
judgment, and that's
Yes.
first
Yes, I
and
see.
foremost what
Fine.
I've got to deal with.
Everybody seems to agree that that's not, well.
Yes, but okay, but I'll deal with it very quickly then. But can I just mention the reason I have to deal with it is because Mr. Perry doesn't actually think that this example is right. So that's why I don't want to just leave it.
Even on the Court of Appeal's view.
Well, as I understand it,
That's what he says, certainly.
yes,
Right.
at footnote 51 of his case. Again, I don't want to tread on Mr. Perry's toes here, but that's why I want to deal with it. And I want to deal with it because it really shows the importance of this argument, that if the Court of Appeal was right, then it would give a huge windfall, and one which could be...
Well, we understand. Sorry, I shouldn't
Yes.
interrupt you, but I thought that's the point made in the commentary and which you've made in your
It is,
case.
yes, it is. And essentially what we say is that on the Court of Appeal, that if the amount on the bottom of the ratio is the amount certified on the warrant of commitment, on my example, it would be 1.2 million. The amount paid would be 1 million, so you get a reduction of 5/6.
So, I mean, the trouble with that is you are simply not comparing like with like, are you?
Whereas if it be right, I mean, it may be wrong, but the suggestion that is made against you is that you start by treating the interest as added to the original sum. So you start in your example not with 2 million but 2.2.
Yeah.
Well, it is, but again,
And then you reduce it by the proportion that 1 million bears to that.
okay, but
That comes out right, doesn't it?
well, with respect, we're
If the premise is right, the arithmetic works.
I don't want to concede that yet because I want to hear how Mr. Perry puts it, but I'm not trying to be difficult.
No.
But I don't want to compare apples with oranges here. We say that this example is right on the Court of Appeal's judgment. So the starting point is I have to deal with the Court of Appeal's judgment.
Yeah.
I'm not suggesting that this example applies to the new case that the respondent is putting before this court. I'm not suggesting that at all. But we do suggest that this is right on the old case, if you like. So, moving swiftly on, we've set out our solution. It's a very simple solution. I'm not sure I need to go through it. At paragraph 41 of our printed case, it relies on the due at the time the period of detention was imposed in section 79. And it leads to, on the example given at 5b, it would lead to a reduction of half for a payment of half of the confiscation order amount, but the accrued interest would remain payable. Can I just say a few words about legislative intent? We deal with this from paragraph 44 of our case. The respondent suggests that the policy of the scheme suggests that interest should be subject to penal enforcement. We don't disagree with that, but we do disagree with what he means by that. So we entirely accept that it may affect the penal enforcement because of subsection 2 of section 10. But we do say it doesn't affect it beyond that because of what we say are unequivocal provisions of section 79(2). And giving a very simple example of that, if an offender doesn't pay anything off his confiscation order and serves the default term in full, the interest accrued would remain recoverable, as we both agree, but it would play no part in the penal enforcement on anyone's argument. So we say that that doesn't fit with the respondent's new position. We've dealt with the fact of the policy in terms of divesting criminals of the benefit of their offending. We say that on the Court of Appeals analysis, that proportioning amounts paid against amounts due at enforcement day raises all sorts of anomalies. So if you pay an amount before the due date, before any interest becomes payable, it's proportioned against an amount that is payable, which includes interest. So on the Court of Appeals judgment, the ratio is against the amount remaining payable, including interest.
Sorry, whether it's my fault. I haven't got that. I expect everybody else has. I simply haven't got that.
I've not put it clearly enough. If
you pay before the due date, then no interest.
No interest has accrued.
Has yet accrued.
Yes,
clearly.
But the ratio, the proportioning, is against a sum which will include interest because
if interest subsequently
yes,
accrues, yes. Well, why not?
Well,
because the amount has been paid before any interest has accrued. So the part payment, in fairness, would reduce it by an amount without any interest.
well, I mean, are you going to come on to? Are you going to be coming back to section 79(2)?
I am, yes.
Yeah, because I mean, it's if you're going to come on to this, it's the words. It's a reference to the sum due at the time the period of detention was imposed, right, which becomes problematical if the period was imposed on the date when the default term was fixed.
Yes, indeed. Well, I mean, we've made our position clear about legislative intent, I hope. And we go on at 50 to deal with section 79(2), but I've dealt with that already. And we've made some points about the Court of Appeals solution being arbitrary and inconsistent at paragraphs 56, and I think I've dealt with those sufficiently as well. Before I sit down, I have one final topic, which is the respondent's new case.
Well, before you come on to your final topic,
yes,
is that going to be 79(2)?
Well, it will include 79(2)
Okay.
again.
I'll be patient in that case.
And are you going to cover the costs and charges point?
I can do.
Please.
Yes.
Can I also ask about some of the particular words which feature? The amount due under a confiscation order, which is section 9, subsection 5. The amount to be recovered from him under the confiscation order, which is section 10(1). And the sum due at the time the period of detention was imposed, which is 79(2).
Yeah.
The first two being the tailored provisions.
Yes.
And 79(2) not.
Well, may we go through those?
And part of the reason that I'm asking you about it is also because of the comparison between section 9.5 and 10.1, you rely upon enforcement in 10.1 being a narrower concept than including the criminal, the imprisonment part of the enforcement, don't you?
Well, we say that ultimately we say that Parliament may not have thought this through. The drafters may not have thought this through.
But if we can just look at it in the
Yes.
bit where, in the tailored provisions, which is section 9 and section 10,
Yes.
and in section 10.1, you're saying that for the purposes of enforcement excludes the serving of the term of imprisonment that might be imposed.
Well, I say that primarily Parliament has in mind the recovery of the benefit, but also the possible increase of the default term under subsection 2.
Yes.
So that appears to, the intention of Parliament seems to be the recovery, plus the possibility of increasing the default term. But it appears that Parliament did not intend, however I might want to put it, the application of it to reducing the term for part payments.
But that means that for the purposes of enforcement in 10.1 means apart from what is covered in 10.2. Because 10.2 is the service of the imprisonment and 10...
Well, with respect, no. What 10.1 firstly does is it sets it up for subsection 2. So 10.1 provides for interest, which is then aggregated, as Mr. Perry says, to the amount to be recovered. So enforcement refers primarily to the recovery of the benefit. Of course, it relates, and we should apply it to see whether it works on the penal enforcement side as well. But I'll come on to that, and we will say it doesn't on the clear wording. But in terms of penal enforcement, what Parliament has certainly had in mind is subsection 2.
Yeah.
I don't know whether...
Yes.
Well, only if you're talking of increasing
Yes.
the maximum, increasing the default period. But Section 10.1, on the face of it, is looking at enforcement more generally and requiring a rather fictional approach, isn't it? You treat interest, which is by definition only due later, as part of the amount which was ordered to be recovered by the original order.
Well,
And if you do that, then you can read that through, perhaps, into Section 79.2 as an amount which was due at the time the period of detention was imposed.
well, with respect, that does some violence to the section.
Well, it may,
What we say here is that you have to follow through the enforcement provisions. So Mr. Perry is right that 10.1 requires the aggregation of the interest to the confiscation order amount. We don't have a problem with that.
except, you say, in relation to any calculation of default term to be served.
Well, that is the effect of
That's
it.
the effect of it.
But that is not the way we put it. The way we put it is you have to look at what's the time that the section refers to. Let me...
The recovery, apart from the default period, will be done, just remind me under which section. Must be some section which says what you can sue for it in a county court or levy execution in some way. How do you do it?
We think section 76 is the relevant provision, which is at 461.
What, warranted distress?
and committal.
Yes, but hang on.
Wait a minute.
When it comes to confiscation sums, there are provisions all over the various confiscation acts for methods of finding the money, aren't there? Appointment of receivers, etc., etc.
Yes.
Managers.
Yes, but in terms of a
cetera.
warrant of distress or a warrant of committal, our submission is that this is where the application of the fines provisions takes us.
Oh, I understand that, but you're
Yes.
being asked about how the money is extracted.
Yes,
And
so,
the answer is that
but it may be
successive confiscation statutes have had ever more complicated
the
provisions.
provision of a receiver or at one point a director of
Yes,
recovery.
and powers of sale and
Yes.
garnishee, I imagine. I can't remember where they are, but I think they're there.
Yes, I'm afraid neither can I, but possibly my learned friends can help.
Attachment, anyway.
Yes, but if we look at 76, because the general scheme applies the fines enforcement provisions in 139 and 140, which in turn apply the Magistrates' Court Act provisions in terms of enforcement. And 76 provides, subject to the following provisions as part of this Act, where default is made in paying a sum adjudged to be paid by a conviction, the court may issue a warrant of distress. So there's no difficulty there in taking up Mr. Perry's new point of aggregating the interest to the confiscation order amount. So that deals...
You agree you can aggregate the interest for the purposes of issuing a warrant of distress?
Well, yes,
That must be right.
yes.
Yep.
But also, we agree that you can aggregate for the most obvious purpose, which is subsection 2 of 10. So even before we get to section 76, we agree with the aggregation there. But when we go to 79, it doesn't work. We go back to 347, which is divider 10, divider 9. Where after a period of imprisonment or other detention has been imposed, and I think both parties are now agreed that that means the default term fixed by the Crown Court, and on any person in default of payment of any sum adjudged to be paid by the conviction, that would appear to actually refer to the sum at the point the default term is fixed. But
Well, if it doesn't, there are words later on which might be said to make that intention clearer.
absolutely,
Where one gets to so much of the said sum, etc.
indeed.
Hang on, read it all through, Mr.
Yes, indeed. So we say that the time, the wording sets the timing at the start of the provision, which supports our argument. But even if that wasn't so, the timing dealt with at the bottom of the provision.
We'll read through the provision, yes,
Yes,
where after a period of imprisonment or detention has been imposed, and you say that's the start.
Let's read in by the Crown Court,
yes,
for the sake of argument.
yes,
On any person in default, etc., etc., etc.
yes, and of any sum adjudged to be paid by the conviction.
Yeah, the period of detention shall be reduced by such number of days as bears the proportion, etc.
The proportion,
As the amount so bears to so much of the said sum,
yes,
which you say is as fixed by the Crown Court,
yes,
and the costs and charges of any distress levied
Yes.
to satisfy that sum, as was due at the time the period of detention was imposed,
yes,
which you say is the Crown Court.
it must be.
So how do the costs and charges of distress possibly be due at the time of the Crown Court order?
Well, it isn't,
Can't be.
but it's expressly in the provision.
Well, I dare say, but it can't exist at the time of the Crown Court order unless you are notionally adding them to the Crown Court order, can they?
Expressly in the provision.
Yes, but 10.1 does the same, says Mr.
Well-
Perry, for interest.
Well, we would say that it's a if that was so, there'd be a specific provision to do it.
But
not-
you see, it's a problem with 79.2, isn't it? That you cannot treat as was due at the time the period of detention was imposed as meaning the sum if you had frozen it at the day of the Crown Court hearing, because the costs of failed distress could not, by definition, then have been incurred.
Well, no, but with respect, so much of the said sum and the costs and charges of any distress levied to satisfy that sum could mean the original amount
see.
plus the costs. But it's not saying that that's the...
But except it says, and the costs and charges of any distress as was due. So it embraces them.
You say if you put that in brackets, it would work for you.
Well, no, the last phrase draws the distinction between the sum due plus costs with the sum due initially.
Well, surely on your analysis, the words and the costs and charges of any distress levied to satisfy that sum ought to appear at the end of the sentence, oughtn't they?
Yes, exactly.
Yeah. I mean, there's a calculation,
Come after.
and the numerator is the amount paid, and the denominator is so much of the sum adjudged to be paid and the costs and charges, as was due at the time the
Yes.
detention was imposed.
But the costs and charges of distress cannot have been due at the time that the detention
Yes.
was imposed.
Yes.
So you've got to treat it as meaning that they're added into it,
Well-
which means that they're retrospectively added in.
Well, yes, but by operation of the statute,
Yeah, I understand that.
whereas the interest...
You say there's nothing
It's
there
not.
for interest.
No, because the deeming provision, if that's the right word for it, is the amount to be recovered.
Yeah,
So it's not. So absolutely, we accept that Mr. Perry is right. That in terms of recovering the amount,
Yeah.
you aggregate, or for tenant two, you aggregate. But here it doesn't aggregate because you're considering a point before the interest accrues. It's not that we disagree with him that there is aggregation. We're not suggesting that sometimes there's aggregation and sometimes there isn't. What we're submitting is that Mr. Perry is eliding two different times. And unless some violence is done to the words of section 9.2 in the last phrase, you simply can't get round that.
Well, you've got to do some violence to it, haven't you? Because to cope with the costs and charges of distress, you've got to modify the expression so much of the sum as was due at the time of the period the detention was imposed. Haven't you?
Well, with respect, I don't follow
I think
that.
so. Okay.
I'm sorry, but
Why not? I mean, are we reading it wrongly? I mean,
well,
I understand why you say it's not clear enough to include interest. I mean, they could have mentioned interest expressly here. But on the face of it, the section is badly drafted on any view, but to make sense of it, you have to, as my lord says, read it as including in the sum due at the time, the period of detention, at least costs and charges which were not due till years later, perhaps.
yes, but well, first of all, in terms of it being badly drafted, it's not in plain English, frankly. It couldn't be suggested to be very accessible, but we don't think that it's badly drafted in terms of what it was drafted for. So therefore, the court should be very slow to read in or out of the section.
You don't need to, you see, if
No.
Perry's right. The whole point is that the reference to costs and charges is there, nothing to do with confiscation, it's there for fines, isn't it?
Well, it might apply to confiscation as well.
Of course it might.
Yes.
But it's there originally, as you would say, in the model of the section. It's there for fines.
Yes, absolutely.
And even in relation to fines, you have to modify the expression as was due at the time.
But it
Well,
is.
I'm not sure. I mean, I'm sort of being left behind by this. You say that's wrong. Is the suggestion that you can only have costs and charges of distress after the imposition of the...
Absolutely.
Why? I mean, you could have had a fine and then you could have had...
No, not
attempt
after
to levy it.
not after the imposition by the magistrates.
Well-
After the Crown Court order. Take the example of a fine, Mr. Weatherby.
Yes.
Forget confiscation for the
Yes.
moment. I'm sitting in the Crown Court, and for some reason or other, I've been persuaded that somebody ought to be fined.
Yes.
Fine in £5,000. I have to fix a term in default. If I were a magistrate, I wouldn't have to, but I do. So I fine him £5,000 and I fix 12 months as the period in default, shall we say.
Yes.
So what...
There can't be any costs and charges of any distress levied to enforce that fine until after I've announced it.
No.
They can only arise afterwards. And yet, if you are right, and, I'm sure, and it seems to be common ground, that the expression period of detention was imposed, where it appears in section 79.2 means the order that I made in the Crown Court,
Yes.
then you have got to modify the expression as was due at the time it was imposed to cope for the costs afterwards, haven't you?
With respect, no. Beyond,
You say not.
Beyond the words of Section 79, that is precisely what it doesn't do. The difference between what I submit now and what Mr. Perry submits now is that he makes the enticing submission that Section 10.1 deems the sum adjudged to be paid to include interest.
Yes.
We say that is generally a correct statement, but in applying the legislation, you have to look at when you are talking about.
Yes.
So where the legislation in Section 76, which we looked at, does not put a previous time on it, then you're looking at it in the here and now. So the sum adjudged to be paid is deemed to include the aggregated amount.
Yeah. But
Okay, Mr. Weatherby, if I can just interject for a moment.
Yes.
The opening words of subsection 2 envisage two circumstances, I think, in which the period of imprisonment may be imposed. One is in default of payment, right? And the other is for want of sufficient distress to satisfy such a sum.
so you say it's only applying to that.
So I think that may be the explanation of a word of reference later on to the costs and charges of any distress levied.
Yes.
If we're dealing simply with imprisonment in default of payment, then I would suggest the relevant words later on when we're dealing with the denominator of the calculation, then when we can ignore the reference to the costs and charges, we're dealing simply with so much of a said sum as was due at the time the period of detention was imposed. And ex hypothesi, interest cannot be due at the time when the order for payment is made.
Yes.
Yeah.
Well,
And can I just follow that up? The word, the so much,
yes.
what does that apply to? Because, I mean, in the example put to my Lord Hughes, where it applies simply to the order made by the Crown Court judge, the whole lot's due at the time it's imposed.
So much is quite a problem, actually.
So, but presumably so much applies in other cases where the order is made after the original order, and so you've had some payment in the meantime.
Yeah.
If there is such a case, I don't know.
Well, certainly under the Crown Court there wouldn't be.
No, this is
because
not
the
just
amount
dealing with
is
the Crown
fixed
Court,
at.
is it?
No, of course, it doesn't. So
We've got to
it
remember
may
that
be,
this is dealing with
so that
a
might be
range
that
of
it deals
circumstances
with...
that aren't in front of us.
When would so much apply, Mr. Weatherby? I expect there is a case, but I can't think of it. Because by definition, if was imposed means by the Crown Court, then so much is by definition all, isn't it?
Mm-hmm.
Yes, it may be that my Lord Carnwath has raised a point in my favour there, because it may be that relates to where the magistrate court fixes the default.
Well, it might. I'm just trying to
period.
work out how.
Well, because if a magistrate's court fixes a fine and it doesn't fix a default period,
Quite.
so if the offender pays half, not the other half, and so on enforcement, the magistrate's court then fixes the imprisonment, but doesn't. I suppose it might not matter whether they do or don't, but
Well, they'll take into account the payment made.
then they'll take into account the amount before. So that would be an explanation as to why so much.
No, it won't, you see, because then by fines £5,000 in the magistrate's court. No, yes, it can be.
As was due at the time the period of
court,
detention was
half
imposed.
has been paid. You come to enforcement 6 months later. They impose a shorter period, but the amount that is then outstanding when they make that order is £2,500, not 5,000. So it's not so much of the sum, is it?
No. I see.
Well,
Maybe.
the amount wouldn't be fixed in the magistrate's court example, and at the time the fine was made. So
Exactly.
it may be that it's the period between then and the fixing that is what so much applies
Yeah,
to.
I mean, in the case of the ordinary magistrate's court fine, if you start at the beginning of 2, where after a period of imprisonment or other detention has been imposed, in that case, that must mean by the fines enforcement court, mustn't it?
Yes. Yes,
So
that's right.
So in our example, that will have been imposed on the basis of 2,500 outstanding.
Yes.
And so how do you get to so much of that sum?
Well, you would get to it in a case where you were within the distress provision, wouldn't you? Because the distress provision postulates that I haven't quite got the procedure. Is it under Section 76 that some court is imposing a period of imprisonment for want of sufficient distress to satisfy some previous order? Yes. And in that situation, by definition, there may have been some successful distress, so the previous order may have been reduced to some extent, but at the time when you're imposing the sentence in lieu of sufficient distress, you're looking at so much of the original sum as was due at the time of that sentence.
Yes.
No, I think that's it.
I mean, I don't know, when is this want of sufficient distress to satisfy a sum relevant? Is it Section 76, and what does it ever happen? It sounds Dickensian.
No, but I mean, this goes back.
I mean, can you put people in prison anymore just because they haven't got enough money to pay this? If it's not part of the original sentence, perhaps you can.
Well, only very limited.
I'm afraid I don't know. Is the answer to that.
Can you still do it for taxes?
I'm
No, I don't think you can. You used to be able to do it for taxes and maintenance, but I mean, not for years.
yes. But going back.
Well, it seems to be within Section 76, which does deal with maintenance orders as well.
Yes.
But,
Well, then maybe.
Yes, but even going back to 79.2, that on the magistrates' court example, the magistrates' court would impose the default sentence in respect of a sum adjudged to be paid by the conviction, which would be the full amount. It wouldn't. The period would be fixed for the remaining amount, which would be the half on my lord's
Yes.
example, but it would be in respect of the sum adjudged to be paid on conviction. So,
Right.
so the working from that, so much would then refer to the half and not the whole. I don't think I made that clear. Perhaps I have to say that again.
Except it isn't in respect of.
No.
It's in default of payment.
Yes.
So it's the whole sum there.
And the default is the unpaid £2,500.
Yes.
I thought.
But the sum adjudged to be paid by the conviction would be the full amount.
I see.
For the default, the imposition of imprisonment in default of payment of any a sum would be a portion of that full amount, and the so much of the said sum would then refer to the half.
I see.
That may.
Well, I'm not
may
sure that really is contemplated by the wording.
It seems to me.
And so on in a case like this, I presume you would say that it may be that section 10(1), which tells us that interest is due while the amount of a confiscation order is unpaid, and the amount of the interest is to be treated for enforcement purposes as part of the amount to be recovered under the confiscation order.
Yes.
That may mean that the interest forms part of the sum adjudged to be paid, but on any view, it can't be part of so much of the sum as was due at the time the period of detention was imposed.
Precisely.
Ex hypothesi, it's only due because it only becomes due after then because the principal sum hasn't been paid.
Exactly. Yes, with respect. So perhaps I can just go through that once more because it is very complicated. That what we say is that Mr. Perry is right that for the purposes of recovery, the confiscation order and the interest has to be aggregated. We have no problem with that. So when you read section 76, there's no problem in terms of the amount to be enforced and recovered. It's not two sums, it's aggregated. When you look at 10 subsection 2, it's plainly aggregated for the purposes of an application to the Crown Court. But when you look at 79.2, it's not that we balk at the aggregation, it's we're saying when do you aggregate? And you cannot aggregate the interest until it's accrued. So,
I mean, that means you accept that it's a sum to be recovered under the confiscation order. You accept that it is a sum under Section 76 adjudged to be paid, but you say that it's not a sum due.
but it's not a sum due at the time the period of detention was imposed.
Have I got it right, though?
Yes.
The distinction is between something adjudged to be recovered by an order or adjudged to be paid by an order, and a sum which is said to be due at the time the order is made.
Yes, it's not the aggregation that we balk at all. It's the fact that you've got to look at a particular point that legislation says that you have to look at. With Section 76, it's the here and now. It's when there's an application to court or for a warrant of distress or whatever. So the aggregation applies at that point. So that would include capital and interest. But here, where you're looking at the application of the penal enforcement, the reduction for part payment, the statute is, we say, it's absolutely clear that it has to be as was due at the time the period of detention was imposed. It's not that there isn't aggregation, it's just that this is applying to a point before the interest has accrued.
But isn't the difficulty about all of this that it's completely artificial, that Section 79 wasn't drafted with this in mind? It's an artificial route to it that you come via now the Drug Trafficking Act in Section 9. You have to treat it as if that amount were a fine imposed.
Yes.
And then you have to say, what is that amount? And you go back through the provisions which say it's the amount that is to be recovered, the amount he has to pay under Section 2. And then you have to look at Section 10(1), and that says that the interest shall be treated as part of the amount to be recovered, the amount he has to pay.
Yes.
And then you have to read Section 79 with that in mind. And you're using the express words in Section 79 to go behind, to look at the reality of when the interest actually accrued. What I'm putting to you, I think, is that the Drug Trafficking Act sets up an artificial scheme. That's a possible way of looking at it.
creates a fiction, and the question is how far you can.
Yes, well, Mr. Perry's word, it deems. And I have no problem with that, as I say, that our submission has no difficulty with accepting that the interest is recoverable. It's just how it's recoverable. And unless Parliament, with any of these provisions, could have put in the addition of interest, it didn't. So we end up with, as the point that my Lord Hughes made about costs and charges. Well, of course, that's always been the case. I think always been the case with the Section 79, that those are contemplated charges directly relating to the amount fixed by the court are to be taken into consideration. If Parliament wanted interest to be taken into consideration within this penal reduction.
So you accept the costs and charges in a situation like the present of a failed distress levied to try and enforce the Crown Court judgment would be within Section 79 and would fall to be treated as due at the time the period of detention was imposed.
That's what the statute says.
Yeah. I mean, the alternative argument would be that you read it distributively and that the only relevant costs and charges intended to be caught at the end of subsection 2 are those which arise in the very unusual situation where the period of imprisonment is fixed for want of sufficient distress to satisfy such a sum.
Well, I don't want to look a gift horse in the mouth. I could have my cake and eat it there. Either of those.
But I mean, I think the trouble is the section is all mixed up together. It doesn't read quite distributively, but it could do perhaps.
I've agreed in my submission with that, I think.
That it was read as that it would apply. Your first answer, you're not arguing primarily for the distributive answer, though it's a possibility.
Well, I wouldn't close it off, but
yes, all right.
No, but I would say that this is why I caveated my approach to INCO Europe. That this is not a provision which is defective, and therefore it should not be read in a liberal way. In our written case, we actually cite further from INCO Europe, which says that even where the strict criteria for poorly drafted legislation is made out, there may be good reason not to liberally interpret a statute. And one of the examples given is penal legislation, which should be construed literally.
Yeah. I mean, your point is a very simple one, isn't it? That that the proportion has to be calculated by reference to the sum due at the time when the period to be served in default was fixed.
Yes.
It's as simple as that.
Well, I'm not sure simple is the right word with respect, but yes. I mean, you know, having made my submissions about the Court of Appeal judgment, this is a new argument that is put up.
Your argument is a nice, simple old one. Your argument is a nice, simple old one, you say.
Well, it is a simple. It is simple.
None the worse for that.
And it was always my intention to roll back to the words that I borrowed from Lord Judge at the start. That in terms of a sentence to be served, that it should be clear and simple. And our submission is that may be a reason why the application of the enforcement provision to reduce part payment reduction simply doesn't apply here, because it makes a nightmare of the calculation, that the prison would have to alter the calculation every day. If a series of payments was made over a week, the calculation would be different on every day. The amount of reduction for the same payment would go down as it went on, which we've suggested is counterintuitive in our written submission. Where the purpose of the provision is to recover the ill-gotten gains of the criminal, to have a reducing effect of part payments would be against the general scheme.
And after all, Parliament can always make another simple amendment to this scheme and make it all clear.
Well, leaving ourselves an escape route ultimately on any of these arguments, we have said that nothing in this case appears to be simple, as the history of it shows, and therefore it should be for Parliament to rectify if our simple solution isn't right. I don't think at this point I can assist more. If,
Well, I think you've precisely hit your time estimate, so that, thank you very much indeed. Yes, Mr. Stanbury.
Nothing to
Mr. Parry.
is that the proportionate reduction of the default term is the period of imprisonment calculated by reference to the amount to be recovered, the term of art used in the 1994 Act, and that this includes interest, and that is, we would submit, the clear effect of Section 10, subsection 1 of the 1994 Act, read in context. And we respectfully agree with the observations that were made in the course of argument this morning that the construction of Section 10 is informed in turn by Section 9.5 of the Act, which in turn is informed by Section 5 and 6 of the Act, which in turn inform Section 2, which is the order made by the Crown Court judge. The order made by the Crown Court judge is an order for the amount to be recovered. And therefore, when Section 10.1 talks of the interest for the purposes of enforcement being treated as part of the amount to be recovered, it's referring back to the order made by the Crown Court, and that is why there is no temporal problem in relation to the interpretation of Section 79, subsection 2. May I just make reference to the relevant provisions very, very shortly? I will be accepting that so far as Section 79.2 is concerned, it is right to say it's a difficult provision, and the reference to costs and charges is not necessarily because there were no costs and charges before any imprisonment was imposed, because there are schemes for enforcement to take place before a default term is imposed. I accept that, but perhaps I can come on to deal with it. As your lordships and my lady may know, the 1980 Act was recently amended, apparently, to modernise it, but it now talks of warrant of control rather than distress. And the warrant of control is where you're taking possession of goods before you come on to impose a sentence of imprisonment in default. The problem being in the magistrates' court, unlike in the Crown Court, there is no obligation on the magistrates at the time they find someone to impose a period of imprisonment in default. Other mechanisms of recovery can be employed.
Does the 1980 Magistrates' Court Act reflect provisions in earlier acts? I assume it does.
Yes, they're really derived from the 1952 Act, but then they go back to the 19th century.
Miss of time. When did Section 79 first come in then? You know?
Well, Lord, it looks as though it was first included in the 1952 Magistrates' Courts Act, and what happened was that prior to the 1952 Act, you had separate regimes for reduction depending upon whether it was a court reduction or a prison governor reduction. And then it became amalgamated entirely into a single provision, but the simplicity that you find in some of the earlier wording was lost by the fact that it was to cater for different circumstances. But may I just go to the Drug Trafficking Act, just to, and before I do so, may I just say this, I do accept it's a simple point. It really boils down to the meaning of section 70, of 10.1 when read together with section 79.2, and we submit that the solution is, as was suggested by my lady in argument, that you really have to read section 79.2 by reference to the specific legislation dealing with confiscation, and it makes it clear, we would submit, that you're dealing with the amount plus interest. So the first point to note, we would submit, is at behind divider 1 of the first volume at page 171 on the memory stick reference, is what a confiscation order actually is. And the court will see, by reference to section 2, subsection 4, that the court, that's the Crown Court, has to determine benefit, and then it's to determine in accordance with section 5 the amount to be recovered. That is the term of art, because the actual order, as the court can see from section 2, subsection 5, is order the defendant to pay that amount. That is the amount to be recovered. And also we would draw attention to the fact that the court will see, when we're having regard to policy here, section 2.5b, that the significance of this point is that the confiscation order is to take precedence over any other financial penalty. That is why it has been singled out as the only financial penalty, certainly so far as English law is concerned, which attracts interest, unlike fines, which don't attract interest. And it's also why it has been singled out as the only order made by a criminal court which is not expunged by serving the period of imprisonment in default. So the scheme of the Act, the grain of the legislation, as we can see, is to give precedence to confiscation orders and for enforcement to be effective. So far as the amount to be recovered is concerned, that's dealt with in section 5, which is at manuscript page 178. And the importance of this point is that the amount to be recovered under the confiscation order is calculated on the basis that it represents an amount that might be realized. So in other words, the scheme underpinning the legislation is that the sum the Crown Court actually orders the defendant to pay is a sum that is available to the defendant. It's the amount that is available to be realized. Section 6, it's not necessary to deal with it in detail, but just to note, it's dealing with the amount that might be realized, which is the value of realizable property held by the defendant, less obligations, and that's ensuring that the legislation is intending to operate on the basis that it removes the relevant gain within the limits of available means. So it's removing the relevant gain within the limits of available means. Then we come on to section 9 at 186 in its in the form in which it was enforced on the day that the confiscation order was made. And the points that we make in relation to section 9 are really twofold. First of all, the whole scheme of enforcement shows that Parliament has given priority to the enforcement of the confiscation order. So, for example, subsection 2 the period in default must be consecutive to any existing term. Then it assists in subsection 3 with determining what a term is by disregarding suspended sentences and matters of that nature. Then subsection 4 makes clear that although being grafted on to the scheme of fine enforcement is the Magistrates' Courts Act scheme, so it's...
Which makes that clear?
It's subsection 4, my lord, in the
Yes,
application
quite right,
of part
yes.
3 to amounts payable. So it,
Yeah.
because it's deemed it to be as though it were an amount as a fine imposed by the Crown Court, it's then linking in the legislation to Part 3 of the 1980 Act, but then at the same time, it's modifying that scheme. So whereas Section 81, for example, contains limitations on enforcing fines against young offenders, those limitations don't apply, nor does the power of the magistrates to remit the fine. And then Section 87 of the Act, so that the court knows, Section 87 is the provision that enables enforcement to take place through the High Court and the County Court. And subsection 3 provides that a designated officer may only take enforcement proceedings after a means inquiry. So it's saying you don't need a means inquiry. You go straight to the High Court or the County Court. But then what the second important point to note from section 9 is subsection 5, and in particular, the closing words of subsection 5, so far as any other method of enforcement is concerned, because we can see that what subsection 5 does is it provides that where the defendant serves a term of imprisonment in default, his serving that term does not prevent the confiscation order from continuing to have effect so far as any other method of enforcement is concerned. Now, the point we make is that Section 9.5, in Section 9.5, Parliament has clearly recognised that serving a term of imprisonment or detention in default is a form of enforcement. That then brings us on to Section 10.1, which we submit is the critical provision, because Section 10.1 is then creating the fiction for the purposes of enforcement, which picks up the language in Section 9, that the amount of interest shall, for the purpose of enforcement, be treated as part of the amount to be recovered. Now, the amount to be recovered is the confiscation order. That's the amount to be recovered. So it's referring back, by reference to the term of art, to the order that was originally made by the Crown Court. The Crown Court was told by Parliament under Section 2 to make an order representing the amount to be recovered, and that is what Section 10.1 is then referring back to. We submit that the appearance of Section 10.1 immediately following on Section 9 and immediately before Section 10 subsection 2 supports the construction for which we contend, because what Section 10.1 is effectively providing for is for a mechanism for interest to count where Section 10.2 does not apply. So in other words, there is a coherence in the way the scheme operates. And the coherence in the way that the scheme operates is whereas Section 10.2 permits the Crown Court to refix the default term if the amount of interest takes you into the upper bracket, where that does not apply because, for example, you haven't been taken into the upper bracket, there is still, nevertheless, a provision to ensure that interest matters, and that's the policy that underpins this provision. Interest does matter for the purposes of enforcement. And it would be inconsistent and incoherent, we would submit, if 10.2 provided as long as you're into another bracket, you can have your default term increased, but 10.1 had no impact whatsoever, whereas the wording of 10.1 is for the purpose of enforcement, for all purposes. So we would submit that the scheme viewed as a whole supports the construction for what we contend.
Can I just confirm that in section 9.1 then, that amount is the amount plus interest by virtue of section 10.1 on your construction?
Yes, I respectfully, on our construction,
Can I just ask, section 9, subsection 4, seems to assume that the Magistrates' Court Act 1980, Part 3 will apply. Is that the best we get by way of a provision that it does apply? Because on the face of it, it only applies to Magistrates' Courts.
It's 9.1 as well, my lord, because it has the effect as if that amount were a fine imposed on him by the Crown Court. And so because it's treated as a fine imposed by the Crown Court, Part 3 of the 1980 Act deals with fines imposed by the Crown Court. And it's also...
Does it? I was looking at it and I see somewhere it says it deals with that. It seems to...
may I just... May I...
Yes.
It may assist, my lord, if I perhaps I can just come on to that, because it's also the position in relation to the legislation, the powers of the criminal, so far as the powers of the Criminal Courts Act is concerned, and also the 2000 Act. But I think it's in the 1973 Act and in the 2000 Act that it's treated for enforcement purposes.
Yes. Anyway,
to be enforced.
Yes.
May I just make? May I just deal with one of the points my Lord Hughes made this morning, early this morning, about when these changes were made and how the scheme evolved, with increasing importance being attached to interest. As the court knows, the first scheme for confiscation was the Drug Trafficking Offences Act 1986, which contained no provisions for interest. The confiscation order was treated in the same way as a fine. It could be enforced and you could have the default term, but interest didn't arise. Then there was the Criminal Justice Act 1988 for other acquisitive offending, and in the form in which it was originally enacted, again, no provision for interest. The change then came about through the legislation with which we are principally concerned, the Drug Trafficking Act 1994. But there was a provision then inserted into the Criminal Justice Act 1988 by the Proceeds of Crime Act 1995, which is in identical terms. Sorry, there was also the Criminal Justice International Cooperation Act, which kicked the whole thing off in 1991. But may I just go to the volume 4, divider 44 at MS 1731. And the reason I'm making reference to this is, and I will be making reference in due course to the Proceeds of Crime Act 2002, but this is the provision inserted into the 1988 Act as part of the confiscation scheme, and the court can see that it's in all material respects identical to the provision in relation to drug trafficking. So 75AA is liability to pay interest, and then it's treated for the purpose of enforcement as part of the amount to be recovered under the confiscation order. And while we're just in this volume, if we may just go to divider 41 at 1638, this was the Criminal Justice International Cooperation Act, and it was interest on sums unpaid under confiscation orders.
Sorry, what was that?
1638. This is just part of the background, but it shows the increasing importance that was being attached to enforcement. So you have a tightening of the scheme as various regimes are brought into force. And it did appear to us that if your lordships and my lady were to grapple with this problem in relation to repealed legislation, it would be unfortunate if the position under the current legislation were left unresolved, because it would inevitably mean that there would be further litigation on that point. Obviously, it's a matter for the court, but given that we're dealing with legislation which has diminishing impact, and there is extant legislation which we would submit is whether the same question arises, and we would submit that the answer is the same, then we would invite the court to consider whether something should be said in relation to that.
Well, we probably need to know what the current legislation was precisely, because
may I just take your lordship very quickly?
Couldn't you give it to us on a piece of paper or something?
Well, my lord, it's section 12.4, which is in the it's actually in the bundles,
right, and
it's in volume 2, divider 24, at MS 874, and it's also, but it's not for any, there's no material distinction. It's also volume 3, divider 31, MS 1210, but the relevant provision is 12.4, whereas in the earlier legislation it's the amount to be recovered. In 12.4, the amount of interest must be treated as part of the amount to be paid. And then the enforcement mechanisms, it's section 35, which is at 919 in this extract, where the director is not appointed as the enforcement authority, but it's really the same point, that it's part of the amount to be paid under the confiscation order.
35.
35 of the Proceeds of Crime Act, 2002. And our submission is that the schemes were each designed to operate in the same way, and it follows that whatever your lordships and my lady decide in the case of the 1994 Act will have an impact on the operation of the 2002 legislation.
And we still have, do we? If via section 35, we would now go under POCA back to section 139 and 140 of the 2000 Act, and via that to the Magistrates' Court Act?
Yes.
And 79.2 is still in the same terms?
Yes.
Got it.
Yes. Although 79.2 was amended to take into account the changes made to enforcement in 2007,
Yeah.
which which is the warrants of control point. So the steps in our argument, just to summarise, is that the decision to make a confiscation order in the first place constitutes a finding that at that time, that is, at the time the order is made, there are realisable assets to satisfy the order. And that is why the language of the legislation is the amount to be recovered, the amount to be paid, and that is what the Crown Court is deciding is available. The second point is the purpose of the legislation is to ensure that criminals, especially professional criminals and those involved in drug trafficking, do not profit from their crimes, and it sends out a strong deterrent message to that effect. That is what this court said in the Queen against Weyer, Volume 5, Divider 62, at paragraph 2, MS page 2006. 3, consistent with the purpose of the legislation, that is to remove from criminals the pecuniary proceeds of their crimes, Parliament intended that the convicted offender should pay the amount to be recovered without unreasonable delay, and provided for a detailed scheme for the collection and enforcement of the amount to be recovered. 4, in the event of delay by the offender, interest accrues on the amount to be recovered or the amount to be paid, and the interest for enforcement purposes is treated as part of the amount to be recovered, or to use the 2002 language, the amount to be paid under the confiscation order. And because the interest is treated as the amount to be recovered for the purposes of enforcement, and enforcement includes committing the offender to prison to serve the default term, it means that the construction of 79(2) does not mean that the sum is a fixed once and for all sum at the time the period of imprisonment in default was imposed. I'll come on to deal with section 79 if that's a convenient moment.
How are you doing in terms of time?
Lord, I hope I can, if I have another 30, 45 minutes, I hope I can get through everything.
We look forward to hearing you further at 2 o'clock.
Thank you very much.